Hello, I'm Robin Stewart. I'm a partner in the Housing and Property Disputes team at Anthony Gold. And today I'm joined by criminal barrister Sebastian from Crucible Chambers, and we're going to talk about the new draft sentencing guideline for housing and HMO offences. Seb, you're a criminal barrister, so your normal day-to-day work involves just standard criminal practice, doesn't it?
Yes, I deal with all sorts of criminal law, from very serious crimes, white-collar crime, and everything, including corporate crime.
But you do have a background in housing as well, starting off working with us at Anthony Gold.
Yeah, I was in the housing and property disputes team as a paralegal from, I think, 2016 until 2018.
What we're talking about today is criminal offences relating to housing. So offences generally committed by landlords or letting agents. And up until now, those offences, when they're prosecuted in the criminal courts, haven't had any specific sentencing guideline, have they?
No, that's right. So the courts have been effectively left to deal with sentence on a case-by-case basis, which to some extent leads to uncertainty for defendants, but also it can lead to confusion and inconsistency for the courts.
So most of the time, there is a guideline. If you're representing a defendant in criminal proceedings, when you get to sentencing, there normally would be a guideline.
Yeah, so in almost every common criminal offence, there is a statutory guideline drawn up by the Sentencing Council, and the courts are bound by law to follow those guidelines.
This new guideline or draft guideline, it's still only a draft at this stage, relates to houses in multiple occupation, HMOs, HMO licensing and selective licensing as well, safety and maintenance standards for rented property, and illegal evictions as well. A lot of people have been asking for a sentencing guideline on these offences for some time. Is that something that you felt was necessary as well?
Yeah, so when these cases do go to the criminal courts and there are prosecutions brought, quite often, up until now, you have been left in the dark in terms of advising your client what sentence they might expect, but also making reasoned submissions to a judge, particularly in this sort of case where the sentence is almost always a fine.
At the moment, at the time of filming, it's still a draft guideline. So is it something which the courts can take into account yet?
Well, unfortunately not. So the courts are not permitted to look at draft guidelines, despite how tempting it may be, both for practitioners and sentencing judges. There are quite clear authorities saying they are only draft guidelines and not for real practical use.
There's probably no point in us going through all of the detail of the guideline because it may change slightly, and if people want to read it, they can find it online and we'll link to it. But in general, it goes through various stages, doesn't it? So we start by looking at the offence itself and get to a starting point, and then the court looks at the specific circumstances of the offence and the offender to work out what would be an appropriate fine. What sorts of things are going to be the most important factors to a criminal court when trying to assess a fine? For say, for example, an offence of managing an unlicensed HMO, how is the court going to go about assessing what the level of the fine should be? Which factors are going to be important in that decision?
Yeah, so this guideline follows the standard route where they first look at the culpability, so the seriousness of the offence, but also that individual's personal culpability in the context of that offence, and they look at the harm it could have caused overall. And in this sort of case, they will look at the, for example, length of time that the property was unlicensed. They'll look at the potential harm or the risk of harm that could have been caused to tenants, and they'll weigh up the various factors in the case, which will of course vary on a case-by-case basis. They will also have to look at the individual landlord or agent's personal circumstances and any personal mitigation that they might have.
I think something we both have experience of is landlords who are being prosecuted are still very cagey about their own financial circumstances and quite reluctant to share that information with the court. Is that something they're just going to have to live with?
Yeah, well, the difficulty is criminal proceedings are public, and I can well understand why individuals feel cautious about putting their personal financial situation out before the court. in reality, because the court is going to be looking at the person's financial circumstances when considering a fine or any benefit from the offending, they will have to consider very carefully putting that in front of the court.
One aspect of the guideline which we're both very interested in and we think is going to be difficult for the courts to apply is the stage that looks at the financial benefit which a landlord has gained through their offending, because the guideline asks the court to look at that and try to make sure that the person who's committed an offence isn't in a better off financial position as a result of committing an offence. Do you think that's going to be difficult for the courts to apply in practice?
I think it will. This guideline is unusual and interesting in that it has currently in the draft, the court is required to add to the fine that they've already settled on the economic benefit of the offending. Now, ordinarily, that might be the sort of thing that is covered by the Proceeds of Crime Act and what we would call POCA proceedings. So it will be really interesting to see how that all works in practice and how courts work out what the benefit could be. It could be the benefit, for example, of not paying the licence in that sort of case. It could be other benefit that prosecutors feel that defendant has had. So it will be interesting if the draft proceeds as it currently stands to see how courts deal with that.
And there'll be a temptation there for courts to try and do a speeded up version of confiscation under POCA, a temptation to do a sort of summary version of confiscation as part of the sentencing exercise, which would be unusual, wouldn't it?
Well, it would, not least because confiscation proceedings tend to have a much deeper look at a person's financial affairs, and it could very well lead to points of appeal. So it will be, as I say, interesting, and it's to some extent uncharted territory for the criminal courts.
Another interesting aspect of sentencing and fines in this particular area is, in addition to any fine imposed by the criminal courts or by the local authority, tenants have the power to apply for a rent repayment order if their landlord has committed one of a number of specified offences. So where that applies, a tenant would apply to the First Tier Tribunal for a rent repayment order, and under the Renters' Rights Act, the maximum amount of that order is 2 years' rent. How can the courts take that into account when they're imposing a fine if someone is being both prosecuted and is or potentially is the subject of a rent repayment order?
That is a very interesting question indeed. And the reason I say that is because courts, when sentencing, can already make an order for compensation to tenants in certain cases. And the guideline says not to double count. But there is a risk, I think, that there will be a sort of double bubble, as it were, if rent repayment orders are sought in these cases. The difficulty is the sentencing judge might not know if they're going to be applied for by the tenants, but they still have to make a decision about economic benefit. So we could see cases where there is a conflict, in a way, between these two jurisdictions.
And this is an area of law that I know you know about because we used to work on these cases together. But I think the average criminal barrister probably has never had anything to do with a rent repayment order, and it might not occur to them to ask the court to take that into account. So I think this is going to be an area where people with a real interest and specialism in housing law, housing legislation, and how that interacts with criminal law will have a real advantage.
Yes, and the same is probably true of district judges and magistrates, who will at the end of the day be passing sentence in these cases. And it will be the job of those representing the person accused to make people aware that there is this separate regime with rent repayment orders and how they could interact.
The other thing that we've talked about is the contrast between fines in the magistrates' court or I suppose in the Crown Court on appeal. Those fines are very different from the financial penalties which local authorities can impose for the same offences. So a landlord who has been managing an unlicensed HMO can be the subject of a penalty imposed by the local authority of up to £40,000. And we were just discussing earlier some fairly recent guidance issued by the government talking about those penalties, which have a completely different system for setting those penalties And the offence that we've been talking about, managing an unlicensed HMO, under those guidelines has a starting point of £17,000, which then the council would adjust up or down based on the particular factors of the case. It's a completely different approach, isn't it?
It is, and fines in the magistrates' court, and all the criminal courts, in fact, for individuals are based on a percentage of a person's income. And so they are completely different. I imagine they will result in completely different levels of fine, depending on whether a person is prosecuted or whether a council goes via a civil penalty. That will, I'm sure, influence decisions made by local authorities and whether they prosecute people. But it will lead to some interesting, I don't know whether they'll be inconsistent or not, but it will lead to some interesting results at the end of the day.
And taking a step back, just looking at this in context, I think we're both expecting that the Sentencing Council will publish this guideline as a final version, and there might be a few tweaks here and there, but it will be basically what we have in front of us now. It's going to make sentencing in some ways simpler for the courts because they'll have a guideline to follow, but it throws up lots of other issues, some of which we've talked about. And is it going to mean overall fines are higher or lower or just a bit more complicated? Do you have any thoughts on that?
I think we all will welcome the predictability, potentially, that a guideline can offer, because you know the things they're looking for. And that means when you are arguing and mitigating a sentence, you know what points are going to apply on the guideline. What I think remains to be seen is whether there will still be a very broad range of inconsistency in terms of how the guideline is interpreted. And guidelines are not tramlines, as barristers like to say. Courts do not have to take the same approach necessarily in every case. But I can foresee, as currently drafted, there is scope on this guideline for submissions made by council to make a very big difference to the level of fine being imposed.
Thank you very much.
Thank you, Robin.
If you're a landlord or a letting agent and you would like advice about a regulatory issue or a criminal prosecution, you can contact our solicitors on 020 7940 4060, or you can find more details about our services at anthonygold.co.uk. You can contact Sebastian's clerks at Crucible Chambers.